Hello, everyone. Welcome to our YouTube live, which is weekly, every Tuesday at 2 p.m. Welcome, Leila.
Thank you so much.
So we have a lot of updates,
Yes.
right? And some of them are kind of good, some of them are scary,
Yes.
and we have a lot to cover. And before we get started, I realized that we just hear a news, maybe yesterday,
Yes.
regarding the H-1B fee, which is announced just yesterday. And it created confusion because just recently a federal court judge issued an injunction
Yes.
and found the $100,000 of H-1B fee that Trump introduced unlawful.
Correct.
But now they proposed even a larger fee, which is $103,265.
Yes.
And it covers much more applications. Initially, the other 100K fee was only covering the consulate applications,
Yes.
but now it looks like this will be covering even change of status applications. And what do we know about this?
Well, it was just announced yesterday. It's a proposed rule, and there's going to be a 30-day comment period. The amount is $103,265, as you mentioned, and it would apply to all H-1Bs being submitted. It's very extreme, and I'm sure there's going to be challenges to it, and we just have to wait and see. But the comment period is very short. It's only 30 days.
Yes. So I was worried both as an attorney and as an employer as well,
Correct.
because I'm about to submit an H-1B petition for my company. And I just looked at the validity time period, and then it looks like they will only issue 30 days.
Yes.
And thankfully, I will be submitting my petition
Before that.
early September, but it is still scary.
Mhm.
What do you think will happen regarding the fate of this new fee?
I believe that this is going to be also challenged, and I believe that a court is going to rule against it, because right now the reason behind it, the philosophy behind it, is that this fee is going to help recover the costs of the immigration system and also encourage to hire Americans. As you know, USCIS is self-funded, and they collect fees all the time. So I really don't understand what they're talking when they're saying that it's going to recover fees for the immigration system.
So they say that
Yeah.
they will do more fraud operations in investigations, and they need more resources for that. I don't know how true that is, because we know that the immigration fees skyrocketed recently.
Yes.
And they are getting much more fees right now. And hopefully the federal courts will not allow this kind of ridiculous amount of fee.
Yes, it's excessive. It's very high.
Yes. And I believe no small or mid-sized employers can hire H-1Bs anymore if this is effective and if it's not challenged. Only like big tech companies can pay this much amount of fee right now.
Even big tech companies, if you look at the kind of employees that they have, the foreign nationals, they have a lot of H-1B petitions, and even big tech companies wouldn't be able to afford this amount for every single petition. That's not only for like a new cap case. This is going to apply for change of employer. It's going to apply for amendment. It's going to apply for extension.
And renewals?
And renewals, yes.
Wow. Unbelievable. Hopefully it will not be passing through the court system. Let's see. And another, this time this is a great news actually from federal court.
Yes.
We hear bad news from the executive department, which is the president and the agencies. And then on the other side, we hear good news from federal court,
Yes.
which is judiciary. What do we know about the 75-country ban?
So we had a ruling on August 21st. Federal court in the Southern District of New York ruled that 75-country ban was contrary to the law, and it also was above the Secretary of State's power to sends a note to the consulate and say, stop processing these applications for these people from these countries, because that's basically discriminating against them based only on their nationality, which is totally contrary to what is required in the INA, Immigration Nationality Act. So essentially, the judge said that that was contrary to the law, vacated the policy, and set aside all the denials that applicants have received, immigrant visa applicants have received. And we'll have to wait and see how it's going to unfold. And if they're going to receive, I personally know a few clients from Iran that have received refusals from the consulate just because of this policy. I'm interested to see how they're going to send maybe an email or some sort of update to say, okay, this doesn't apply to you. It's time for you to have your visa issued. I'm very interested to see how it's going to unfold.
Definitely. So the thing that I love about this judgment, that it doesn't cover only the plaintiffs in that particular case.
Correct.
It invalidates the ban altogether.
Yes.
And the judge says that this is patently unlawful,
Correct.
which is a very powerful phrase,
yes,
in my opinion. So many people, even people who applied for EB-5 program, who invested more than $800,000 in a U.S. project, they were denied or they were refused visa because of this policy. It doesn't make sense because it's a public charge ban.
Mm-hmm.
But even EB-5 applicants who invested hundreds of thousands of dollars in the U.S. are being rejected, refused because of this ban. And I am glad that a judge invalidated it right now. And more interestingly, I had a lawsuit pending as well for a client of mine. We filed a Mandamus lawsuit, and we also claimed that this ban is unlawful. Just this morning, I received a call from U.S. Attorney's office in New Jersey, and the U.S. Attorney's, the assistant U.S. Attorney who is assigned to our case, told me that, like, could we agree on a 30-day ban, because there are internal discussions in the State Department going on, and I am hoping that we can resolve this case amicably by issuing the visa, and then we don't have to fight over motions and etc.
So we're already seeing an impact. That's really good.
Yes. So we received the good news. And a couple of weeks ago, when I was asking about the positions of the agency on this case, they told me that they were going to fight it. And after the Southern District Judge's decision, thankfully, they are kind of stepping back.
That's excellent.
That's excellent news, yes. Yeah. And now another bad news from the agency's State Department. They say that they are revoking 200,000 U.S. visas.
Yes.
What do we know about that?
Well, what we know is that what they're claiming is that the visa holders are non-immigrants who use these visas and entered the U.S. and later claimed asylum. Those are the people that they're going after, and they're revoking their visas only because they claimed asylum. They're saying that this was a misuse of the visa, and therefore they're going to revoke their visas. And that applies to visitors and also non-immigrants that are here on work visas.
Yes, so we know that they don't allow people to come through the border, and there might be a logic of it, okay. And people also have non-immigrant visas, and if they're afraid of going back to their home country, they can apply for asylum in the US.
Yes.
And now they are kind of limiting that, and they introduced 2 new questions. Are you aware of that?
No.
They are asking at the consulates to non-immigrant visa applicants. The new 2 questions are, one of them is, have you ever been persecuted at your home country? Or are you afraid of being persecuted in the future at your home country? So they are asking these two questions, and if an applicant says yes, then they are getting refusal or denial from that visa application. And if they say no, and if they come to the US and they seek asylum afterwards, they will be told that, oh, you gave false information to US government. So it is very scary and restrictive move that we are seeing. Actually, before they publish this news, the amount of visa they are revoking, 200,000 visas. A few clients of mine told me a few weeks ago that they received emails from US consulates in their home country saying that their visas are revoked. So it's kind of, ejecting fear.
Correct.
Because there is no effect. If the applicant has already sought asylum in the US, they will not be traveling outside if they are still pending status.
Correct.
So the only effect is that it's fear.
Yes, receiving that email.
Yes.
So what happens if somebody comes to the US and then there's a change of circumstance?
Yes, so they can always argue that. And I also know that based on precedent cases, even if an applicant uses a fake passport, for example, during the entry, they can still claim asylum and they can still get approved, saying that it was the only time they had to give false documents and information to US government because they were afraid of persecution in their home country. And after that, they never used fake documents, for example. So there are some precedent cases that allows it. So I don't know how it will work out in light of the new questions.
Sure.
But if an applicant escapes from persecution, there might be some leeways.
I'm intrigued to see if they're going to add those questions to the DS-160.
Yeah, let's see.
Yeah.
I mean, they are revising a lot of forms right now. Okay. Do you want to talk about the I-485 green card application forms?
Yes. So as we discussed in our previous lives, there are going to be changes to the public charge rule. And because of that, they're revising the form I-485, which is filed to apply for an adjustment of status for a green card. I believe we haven't seen the forms yet, but I believe there are going to be a lot of questions about if you've received any public tested benefit. And based on that, they're going to assess whether you are inadmissible due to the public charge rules. I heard that they're going to be, at the interview, the officers are going to assess and see if you've received any benefits. And even if you haven't received any benefits, because of the new public charge rule, they will assess based on the totality of the circumstances and try to decide whether you will use public benefits in the future. And if they believe you will, they can invite you to post a public charge bond. And if that's the only reason, you will become inadmissible and your green card is going to be denied. And it is only if the officer invites you, then you can post a bond based on what the officer calculates. There's a new form, I-945, that would also have to be completed. It is my understanding that you either will be notified at the interview or you will be sent a request for additional evidence or a notice of intent to deny, which will instruct you to complete the form and submit the bond.
Leila, I am very confused about all these bonds. Recently they made an announcement saying that if you want to get a visa,
yes.
If you are from certain countries, you have to post a bond. I don't recall the exact amount. Was it $20,000?
Yes.
Or $50,000?
Between 15 to 20, the officer will decide.
Okay.
Yeah.
So if I get a visa, let's say tourist visa, and if I'm from a certain country, I need to post a bond.
Correct.
And if I'm in the US and if I apply for a green card based on, let's say, marriage, and if the officer thinks that I will become a public charge, then the officer will decide on an amount of bond.
Yes.
And then after how many years? 5 years?
Well, basically what they're saying is that the way that the officer will decide how much bond you have to post is they will have to analyze how much benefits they think you will be eligible for in 5 years. And based on that,
Incredible.
They give you an amount.
So if the officer doesn't like you at the interview, they can increase the bond amount. This is like very discretionary, and I hope that there will be lawsuits about it. And most importantly, we will have new forms published on that will be effective to be used going forward after September 18.
Correct.
And they did not even publish the form yet.
Correct.
So they say that they will reject all the outdated forms after that date, but they haven't still published the new forms yet.
Correct.
So people be very careful. Do not use the 2025 edition form if you apply for a green card after September 18, or your case will be rejected.
Correct.
This is very
no
critical.
Grace period.
Yes, no grace period at all.
Yes.
All right, and this was a bad news too. So, and I want to share one good news that our client was granted green card after we filed a Mandamus lawsuit in the Northern District of New York. This particular client was granted asylum. And he applied for a green card 14 months ago.
Mm-hmm.
And we thought that 14 months was a very long time. And we filed a Mandamus case for them. And we received the approval less than a month after filing the Mandamus lawsuit. And there was no asylum interview held, green card interview held. So it was very helpful. Still, the federal courts are very effective. And if your application has been pending for a long time, meaning it can depend on the case type. If let's say it's a work authorization application, even as little as 3 months can be a good reason to file a Mandamus lawsuit. But if there is a, let's say, green card application pending, then generally I recommend filing the Mandamus lawsuit after 1 year. Another important decision that we received last week, that we had a client who is from Azerbaijan. He had a pending asylum case, and then he was detained by ICE in Pennsylvania on July 31st, and we filed a habeas case for them. Mm-hmm. Because the immigration courts do not issue bonds for the people who enter through southern border. Either like they came with a parole, or they just entered the U.S. without any papers or admission. So this was the case. The immigration judge was not going to hear the bond motion at all, and we filed a habeas case with the federal court, and then the federal judge ordered that an individualized bond hearing to be held in a week, and we also prepared the bond motion with the immigration court afterwards, and we got the bond, and it was just $2,500. Wow. You know, recently we hear bond amounts. Maybe sometimes $20,000, sometimes even $50,000. So our client was very happy after getting just $2,500 of bond amount, and he had a wife and a minor child. So it was very important to go back to work for the family. So they are happy. I know that the September visa bulletin was just published.
Correct.
Do we have any important updates on that? Or
well, as far as the employment-based visa bulletin, it really has not changed. It's basically the same as it was in August. But in the family-based, there was a movement in I think the most movement was in F3, married children of U.S. citizens. It moved about 20 months, I would say. Yes, about 20 months. Yeah, that was a big movement. And also in F4 for siblings of U.S. citizen. Also, I think in that case, it moved over a year.
Over a year? That's good news.
Yes.
So it's not like 18 years anymore, maybe 17 years?
Yes, correct. And also in F1 category, there was movement about 8 months. It's still good news when you see this, especially in the family-based visa bulletin, where sometimes it even retrogresses. It's still good news to hear that it's moved and it's advanced as opposed to retrogress.
So you did not mention F2A, right?
It has not really moved. It's the same.
It's like
it's very, I think, a month.
Maybe 4 weeks.
Yeah,
So it's
maybe a
almost
month.
current.
Yes,
So
yes.
it's August 22.
Yes.
I guess so. It's still very good.
Yes.
Almost like a U.S. citizen spouse.
Correct.
Yes. Okay. All right. So let's switch to questions if you have any. All right. I think we have a handful of questions. Let's start with one of them. I have an I-140 EB2 NIW application since October 2024. Oh my gosh, it's like 2 years.
Yes.
Is it normal? Not
No.
very much, right?
No.
Is there a chance to file a mandamus case? If yes, what will be the difference between premium processing and mandamus cases in EB2 NIW? So in my opinion, it doesn't make much sense to file a mandamus because there is premium processing available. And premium processing gives you probability of a decision in 45 days, right? And for mandamus, it is most of the time more expensive, and the government will have 60 days to respond to lawsuit.
Yes, they can also ask for an extension.
Yes. Do you see any value by filing a mandamus rather than doing a premium processing?
No, I think in this case I would go with premium processing first and see if that's going to cause an RFE, maybe a request for additional evidence, or an approval.
Yeah.
Yes.
So the only reason sometimes people are worried about premium processing is that it increases the chance of RFE, and they don't want that. And if a federal court lawsuit is involved, I think it can have the same effect.
Yes.
So
I think
the officer is in rush, and then
in this case, since it's already been pending for such a long time, I don't think it increases the chances of an RFE as much as when you file it outright with a premium processing, where they have 45 days just to respond from the beginning. But over here, it's been pending for some time now.
That is so sad, though. You have to spend that $3,000 almost after 2 years. I mean, yeah. Anyway, another question. I submitted my STEM OPT application on June 5th and attended my July 1st USCIS appointment for photo capture, though they did not take my fingerprints. Okay. All right. Meanwhile, my EB2 NIW was approved, but I haven't filed the second stage I-485 adjustment status yet. I did not want to take a risk for my STEM OPT. What should I do? So they filed for STEM OPT, and they did not file the I-485 adjustment. So why does it make sense to wait for the adjustment of status?
So I believe that there are theories about if you apply for an adjustment of status, you take yourself out of student visa. So I think in this case, the applicant is trying to have that OPT in hand before they apply.
So do you mean for OPT, you have to have a non-immigrant intent?
Yes.
And then if you file I-485, there is an immigrant intent. But in practice, do you see that much effect? Like, did you see any OPT denial if there is an I-485 pending?
Not if it is pending. I haven't seen it. No.
No, I don't think I have seen that either. So the risk, I think, is very minimal. But we are under Trump administration, so nothing is for sure. So. So if you want to be in the safest zone, then you may want to wait a little bit. And if you are in need of EAD based on OPT right away, and it looks like you filed it on June 5th, so it's been almost 3 months. And if they don't approve it timely, I was gonna say that you can do mandamus lawsuit, but I believe STEM OPT also has an option of premium processing. Am I
Yes,
right?
it does.
So it makes sense to file a premium processing and not file mandamus, in my opinion. We do file a lot of mandamus cases for EAD delays
Yes.
right now, but in this case, STEM OPT has the option of premium processing.
Correct, yes.
All right. Murat Verdiyev, I have my Asylum biometrics appointment this Thursday. I have an active I-20 and OPT, but I am still concerned. If ICE detains me, what should I do? Should I keep your number and my family's number written on paper? What precautions do you recommend? So if there is an active status like F1, I don't see a meaningful risk of detention. But it is still making sense that you can have our number so that in case of an emergency, or you should have a friend of yours with you, maybe they can contact us as soon as possible so that we can take action. Other than that, I am not overly worried about that.
Yes. Yeah.
Am I right?
Yes.
Okay. Ahmet Dalkıç says, I filed asylum based on being gay. 6 months later, I developed feelings for women and realized that I may be bisexual. If I marry her, could I get a green card? My I-589 mentions membership in a particular social group, but my statement focused on being gay. How do you think a marriage officer would view this situation? Would he go in detail and read my statement to check if I was a gay? Yes, definitely. I mean, totality of circumstances, right?
Correct, yes.
So they can review everything, and they may want to see whether you were always truthful to the U.S. government in your statements and declarations. So if there is a asylum application involved, even under Biden administration, I used to see during the adjustment of status interviews based on marriage, I used to see the asylum packages on the desk as well. So they do look at both applications, and if they see any discrepancy, they can go very much into detail. And also, we now have a YouTube video published on our channel. You may want to visit that regarding the I-485 interviews. We talked there about the Stokes interview where they separate applicants and then spouses and then interview them separately. So there might be that. And I can also expect a fraud investigation or site visits. That is also possible, right?
Yes. And my understanding, previously they were also looking at social media to see if they can find any discrepancies on your social media.
Yes.
As well. So
yes. So we also know that the stance of Trump administration about sexual identity. So
yes.
I would be more careful in this situation. Do you have anything else to say? Okay. Did we answer? Yes, I think we did answer this question. Okay, I think there are duplicate questions here. Emre Doğan asks, if an I-130 is unfairly denied after an FDNS site visit and no response, how long does the AAO appeal take on average? So we recently did some I-290B appeals with the Administrative Appeals Office, and they were pretty quick, 2 months, 3 months after not I-130 denials, but they were I-485 denials based on pro se applicants' mistakes. Pro se meaning without an attorney. So they tried to do their forms and applications themselves, and then it got denied because of a mistake, or they didn't even cure after the RFE. And the applicants came to us. We filed I-290B timely. You only have 33 days.
Correct, from the date of the letter, yes.
Yeah, and very, very quickly, sometimes in a few weeks, we got the reopen decisions from Administrative Appeals Office. But if it is an I-130 denial after an FDNS visit and NOIT response, in the alien file, there should be a lot of documents and evidence and explanations from the adjudicating officer. So definitely it might take a much longer time, and I would expect a year can be very reasonable.
Yes, my experience is similar. In a case where it was an I-140 denial, it took about a year, but in a case where it was a change of status denial, it was fairly quick.
Yeah. So it depends on the case type.
Correct.
And also we received one I-140 denial based on EB1, and the officer initially found 4 criteria to be met, and at the second stage, they denied the I-140 petition. We did file an Administrative Appeals Office 290B petition, and AAO did not give us the decision maybe for about 20 months.
Wow.
I had to file a mandamus against AAO, and we received the decision fairly quickly after that. Yes. Another question. I applied for EAD previously, no biometrics. Currently, visa and EAD expired, but have valid J2 for 3 years. My wife starting academic training. I applied to renew EAD, but got biometric appointment and worried. So as much as I say that many applications and petitions did not require biometrics appointments previously, but now they are required. So it's kind of a standard procedure, and there is no need to worry much. Sure. What do you think?
I agree. I've even seen cases where husband and wife applied, and one of them, they said, we're going to use your previously submitted biometrics, and the other one, they said you have to come for our biometrics, and there were no issues. I really feel like they're trying to send as much as they can. Some offices are still waiving it, but I wouldn't worry.
I wouldn't
especially
worry
if he's in valid J2 status.
Yes.
I would not worry about that.
Yes, so everyone is scared right now.
Yes.
Unfortunately.
It's normal.
Yes. Okay, so Adam says, don't forget to like the stream. Yes, everyone, please. We need that button to be pressed a lot. And if any of your friends in need of immigration advice, you can share the channel with them. It would be helpful for us and for them. Which asylum office is better, Chicago or New York? My case is currently assigned to the Chicago office. What kind of issues might arise if I move to New York? So in my experience, they are very similar. I don't see many difference. For example, the only problematic place I can say is that New York. They used to, I heard it, they used to have pretty good approval rates, but they found a fraud after an investigation, chain of fraud by Chinese asylum seekers, and then they became very suspectful.
Wow.
And now the current approval rate is 8%.
Wow.
I remember attending an asylum interview at New York asylum office maybe 4 or 5 years ago. I was almost giving up being an asylum attorney. It was a very tough interview. So, but New York or Chicago, they are very similar in approvals, in my opinion. Okay, do you want to take this one?
Oh, sorry. Did I change anything?
Yes.
We plan to apply for NIW. My wife completing PhD and accepted for postdoc in AI and health outcomes, but she does not have much publication, subject to 2-year home residency. How soon should we start? So in this case, I see that she's subject to the 2-year home residency requirement.
So does it have any bearing?
It doesn't have any bearing on the EB2 NIW. It will have bearing on applying for an adjustment of status.
Yes.
So that's,
or strategic planning.
Yes, for planning. But it really doesn't, like, just having publications doesn't make you eligible or ineligible for an NIW. There's a lot that goes into evaluating an NIW. Definitely, this is a good field, AI in health, and I believe that that is something that would benefit the US. So it's very difficult to evaluate an NIW, but just not having publications is not a reason to not want to evaluate and move forward and do some research on it.
Yeah, so I remember the Biden administration mentioned that, like, they publicized it on the White House's website.
Correct.
That if you work in AI related fields, it is a good reason for you to be a candidate for NIW.
Correct. Yeah.
So we know that for sure. So AI is a very hot topic, and EB to NIW, that is one thing. The other thing is, I think the proposed endeavor is much more important or critical for NIW applications. So you have to have a project, you have to work on something which is very meaningful for the US or US national benefits. So the publications itself, like, we should take a look at the endeavor and your background, whether it fits or not.
Correct. Yes.
And regarding the 2-year home residency, if you have an I-140 approval, the I-140 doesn't expire, as much as I know, right?
No, it does not expire, and it depends on where the applicant is from, because, as you know, I think it was end of 2024 or 2025, where the list was totally revised. And maybe initially when they received the visa, they were subject to it, but they might not be subject to it anymore.
Yes, I was going to say that. It's a very good point. So I think the name is Turkish, and
Turkey was removed.
Yes, but if the position, or if the J1 program was sponsored by the Turkish government, for example, then they can be still subject. I don't know, or some medical surgeons can still be subject to that requirement. But this is AI, but it says AI in health. Mm-hmm. I'm not sure if they are doctors or not, but most 2-year home residency, most people who are subject to that requirement are no longer subject to that. So please double check. And you can question that. You can make an inquiry with the State Department to see whether you are still subject or not.
Yes.
I think we covered a lot. That was a good question. I'm a citizen, and we applied for only I-130, and my spouse is waiting out of country, and I live with him for a while now until approval. So there is no question involved. But I understood the question. So if a U.S. citizen petitioner lives outside of the U.S., they have to show during the immigrant visa interview, that the petitioner will relocate to the U.S. after the visa issuance, and to show that they have to provide evidence like job offer or lease agreement or similar things, that you have made your plans to relocate to the U.S.
The domicile is what is the controlling factor. So as long as they can prove that their intention is to live in the U.S., that's what the visa officers are looking for.
Do you have any other evidence coming to your mind?
It's any evidence that shows the person's intention is to stay. Some people in the past have used, like, they enrolled in school, and just because they enrolled in school, and it's a 4-year program, that shows your intention is to stay in the U.S. for 4 years, or you lease the car for 3 years.
Okay.
That
even
shows,
those.
yes.
Okay. Yeah. Another question: how long should I wait to file a mandamus after filed I-485 EB3? What is RD? RD March 30. Is it PD?
I think it was PD.
It's priority date March 30. PD current all the time. Interview waived in Boston. Unfortunately, still have no EAD. tried to expedite 5 times. So I remember answering these questions maybe last week, I don't know, but generally a year is a good time. After a year, you can file a mandamus, and if it is March 30, 2025, I would file a mandamus right now. But if it is March 30, 2026, it's been just almost 5 months, right?
Yes.
So it can be early. We filed a mandamus in New Jersey after 6 months of waiting period. That case is still pending. That case was about EB5, I-485. So I-526 was approved, and the applicant filed the adjustment status application, and they have to enroll in school, and they need to get the green card to get the student loan. They are still not eligible. So we filed that case a little bit earlier than our standard time. So if you have some kind of emergency, you can do early, but generally I would recommend a year of waiting before filing a mandamus.
But for the EAD, because he says he has not received the EAD, for the EAD,
for EAD you are eligible even after 3 months because having no EAD is very critical. You cannot work, and you have a lot of expenses living in the US. So the stakes are very high, and the courts will see it. So, and the USCIS will not fight that lawsuit, in my opinion. So definitely, if you want to file a mandamus for EAD, it really makes a lot of sense, especially after expedited processing application denial. So definitely. What's the rule in the USA for someone who has recently converted from a religion and become an atheist, like the asylum seekers? So for an asylum application to be approved, the applicant has to show that there is a genuine fear of going back to their home country, right? So if an applicant has converted in the US and the application has already been pending, I don't think it would make a lot of sense for the adjudicating officer. But if you are planning to apply for asylum right now after converting from your religion, then there might be a chance depending on the circumstances in your home country. And you have to understand that there has to be harm affiliated with this protected ground. So if the potential persecutor doesn't know that you converted, how come will you be able to present a case here? So I'm not sure. So if you are an outspoken person, maybe there might be a case, but in my opinion, it might not be as strong as like the persecution at your home country prior to coming to the US.
And so, converting and becoming an atheist is hard to prove. Like if you change your religion and you become Catholic and you go to church, it's easier to prove. But
become an atheist. Yes. And don't forget that these applications are not being approved quickly, easily. We are under Trump administration. You have to have very strong evidence, or you have to be very credible about that. Another question. Hello, I am an asylum seeker recently diagnosed with cancer. I have Obamacare and will soon marry with a citizen. Will my health insurance be considered public charge? Thanks. So in general, getting an insurance from marketplace doesn't make you ineligible for the green card. However, they are kind of revising the public charge rules, and we are not sure whether it will be considered as public charge or if the adjudicating officer look at your case in totality, if they think that, because they are asking about illnesses as well, right?
Correct.
So this is so cruel, in my opinion. If someone, I'm so sorry to hear that, by the way, if someone is diagnosed with cancer and they are now worried about
Yes,
getting
correct.
rejected or denied from an application, immigration application, it should be very problematic. Hopefully, the officer will be understanding it, but generally, food stamps can be considered, for example, for public charge, but traditionally, getting the Obamacare or health insurance from marketplace doesn't make you ineligible, and I hope it will still be the case, but I am not 100%
I think the
sure.
standard is if it's means tested or not. So if you're buying insurance through the marketplace and it's not Medicaid, then it should be fine. But if it's Medicaid, I believe that's going to count towards the public charge rule.
So you say private insurances are not problematic, but
Yeah.
the Medicare
if it's
can be
means tested, that's
Okay.
the standard. And if that's the case, my suggestion to this person is to apply before September 18th, because you will be using the older forms. My understanding is that they will look at benefits you received before September 18th and what you received after September 18th. So there's going to be two separate standards.
Definitely. So the new form that will be published very soon will have a lot of, we expect that it will have a lot of more questions on public charge. So if there is a chance that you marry and apply for green card quickly before September 18, it might make a lot of sense. I'm not sure if it is possible. You only have a couple of weeks to do that, and you have to get the medical examination report as well. So it might not be as easy, but if there is a chance, definitely consider it. Okay. All right, so we answered the other questions, and the last one is there a timeline for court decisions affecting new initial DACA applications? So I am not an expert in DACA applications, but as much as I know, they still don't accept initial DACA applications. You can definitely renew it if you are a DACA holder already, but as much as I know, they don't accept new applications. Do you have anything else?
Yes, my understanding is maybe he's asking, I believe there was some court challenges. Maybe that's what he's asking about, but my understanding is that no new applications are being accepted. Yes.
Okay.
Even the renewals are taking a very long time nowadays.
Definitely. All right, so we have concluded all the questions. Thank you everyone for joining us today. We will be live at the same time next week, 2 p.m. Tuesday. Thank you for joining again. Thank you, Leyla.
Thank you for having me.
Have a great one.
You too. Bye-bye.